Be ready for dictation. Start. In this batch of transferred cases, transfer petitions, writ petitions, and the petition for special leave to appeal, the challenge is to the Constitution, which came into effect on 14 January 2019, whereby the Parliament has amended Articles 15 and 16 of the Constitution of India by adding two new clauses, that is, clause bracketed 6 to Article 15 with explanation, and clause bracketed 6 to Article 16, and thereby the state has been empowered inter alia to provide for a maximum of 10% reservation for the economically weaker sections of citizens other than the scheduled castes, the scheduled tribes, and the non-creamy layer of the other backward classes. At the outset, it needs to be stated that the amendment in question does not mandate but enables reservation for EWS and prescribes a ceiling limit of 10% in a very brief outline of the forthcoming discussion. It could be noticed that the challenge to the amendment in question is premised essentially on threefold grounds. First, that making of special provisions, including reservation in education and employment on the basis of economic criteria, is entirely impermissible and offends the basic structure of the Constitution. Second, that in any case, exclusion of socially and educationally backward classes, that is, SCs, STs, and non-creamy layer OBCs, from the benefit of these special provisions for EWS is inexplicably discriminatory and destroys the basic structure of the Constitution. And third, that providing for 10% additional reservation directly breaches the 50% ceiling of reservations already settled by the decisions of this court, and hence results in unacceptable abrogation of the Equality Code, which again destroys the basic structure of the Constitution. Per contra, it is maintained on behalf of the sides opposing this challenge that the amendment in question, empowering the state to make special provisions for the economically weaker sections of citizens, is squarely within the four corners of the Constitution of India. Rather, making of such provisions is necessary to achieve the preambular goal of justice, social, economic, and political in real sense of terms. It is also asserted that there is no discrimination in relation to the classes that are excluded from EWS for the simple reason that the existing special provisions of affirmative action in their relation continue to remain in operation in the future as regards the breach of 50% ceiling of reservations. The contention is that the said ceiling is not inflexible or inviolable, and in the context of the object sought to be achieved, 10% has been provided as the maximum by way of the enabling provision. With the foregoing outline, we may usefully take note of the reference made to the Constitution Bench for determination of the substantial questions of interpretation of the Constitution as are involved in these matters, and the questions formulated while commencing the hearing by an order a three-judge bench of this court took note of the issues arising in these matters and referred the same for determination by a constitution bench, while observing inter alia as under by virtue of the impugned amendments very constitution is amended by inserting new clauses in Article 15 and 16 thereof, which empower the state to make reservations by way of affirmative action to the extent of 10% to economically weaker sections. It is the case of the petitioners that the very amendments run contrary to the constitutional scheme, and no segment of available seats or posts can be reserved only on the basis of economic criterion. As such, we are of the view that such questions do constitute substantial questions of law to be considered by a bench of 5 judges. It is clear from the language of Article 145 bracket 3 of the Constitution and Rule 1 bracket 1 of the Supreme Court Rules 2013, the matters which involve substantial questions of law as to interpretation of constitutional provisions, they are required to be heard a bench of 5 judges whether the impugned amendment act violates basic structure of the constitution by applying the tests of width and identity with reference to equality provisions of the constitution is a matter which constitutes substantial question of law within the meaning of the provisions as referred above. Further, on the plea of ceiling of 50% for affirmative action, it is the case of the Respondent Union of India that though ordinarily 50% is the rule, but same will not prevent to amend the constitution itself in view of the existing special circumstances to uplift the members of the society belonging to economically weaker sections. Even such questions also constitute as substantial questions of law to be examined by a bench of 5 judges pursuant to the order aforesaid. This batch of matters has been referred to this Constitution bench for determination of the issues arising from the challenge to the 103rd Amendment. The court is, after pursuing the issues suggested by learned counsel, stopped